WBAP, Byron Henry, kind enough to join us to give us some insight into this decision by a judge in Asheville, North Carolina. This has to do with the North Carolina gay marriage law. Has nothing to do with that bathroom bill. Am I right about that, Byron?
That's correct. This has to do solely with judges recusing themselves from performing marriages in North Carolina.
And it is against your religious beliefs, right?
That's right. There's a statute in North Carolina passed a while back when all the same-sex marriage hubbub was going on that says judges can recuse themselves from performing all marriages, same-sex or otherwise, for 6 months for religious objections. And that law has been on the books since then, and a lot of judges, about 5% of magistrates in North Carolina have taken advantage of that law. There has been a whole lot of publicity about it, but now there's been a lawsuit that was filed and most recently, as you mentioned, dismissed by a judge by some couples that sued saying the law was unconstitutional.
So what kind of can of worms does that open up if a judge decides to bring in his own personal beliefs on what a state law says? It sounds like the judge is kind of making his own law.
Well, the issue becomes, of course, when you have the clash of constitutional freedoms and duties. And one issue you have is there's always been the ability of judges to recuse themselves, for instance, from cases and other matters in which their personal beliefs or there could be bias. And, of course, there's been lots of calls from the left for a lot of conservative judges to recuse themselves from cases when they've expressed their beliefs in public or given speeches and talked about their religious beliefs on such things as abortion. So in those cases, a lot of the left like the judges to recuse themselves because they don't think they can be fair. In this case, it's just another example of judges being able to exercise their discretion and say, this is something I probably shouldn't do. It's against my religious belief. And it is neutral in the fact that they have to recuse themselves from all marriages. It's not just same-sex marriage, so they're not picking and choosing who they're going to marry.
Okay, one of these couples was an interracial couple, right? How did that figure in?
Well, it was the interracial couple, and I believe, if I remember right, it was the interracial couple that actually was part of a lawsuit years ago when a judge refused to marry them on religious grounds because they were interracial. So as a symbolic gesture, they are attempting to say that this law would open up judges to the ability to deny marriages based on race. But, of course, the judges don't have to state why they're not performing marriages. And, of course, they can't pick and choose. The way the statute is written, they have to recuse themselves from all marriages. Unlike that judge back then, he was specifically marrying people and then refusing to marry interracial couples, and it was public. This is a private recusal from all marriages. So there's a little bit of a difference, but that's how the interracial angle figured into the case.
Byron Henry, as always, we appreciate the legal expertise that you bring to the morning show.